Let's go ahead and continue with our discussion of written contracts and the statute of frauds. Before I get on to the last category, though, I want to mention what needs to be included in the writing. We keep talking about the statute of frauds requires that the parties have a writing that is signed or acknowledged by the defendant or the one who's going to deny the existence of the agreement. Well, so what needs to be in the writing? And I have a slide just on this. It says a writing needs to contain the defendant's signature, obviously, because that's part of the rule, and it must state with reasonable certainty the names of the parties, the subject matter, and the essential terms. Basically, it must be clear and complete enough for a court to determine the party's intent. Now, we already know this rule from the common law because we know at common law an offer is not valid unless it's sufficiently definite, right? We need to have the essential terms included, like who, how much, some indication of when or how long, right? Those are the essential terms that need to be included in any agreement or offer to make it valid under the common law anyway. So it makes sense that the writing commemorating a common law contract would also need to include those specific essential terms. Okay, so with that said, our last category under the statute of frauds actually comes from the UCC. The UCC has its own statute of frauds, or version of it, that requires contracts for the sale of goods, under Article 2, that are in excess of $500 to be in writing signed by the defendant. Okay, notice on the slide I put 500 and then in parentheses 5,000. That's because there's a revised version of the UCC that's going around to the various states, legislatures, and some are considering passing it and others are not possibly, but the revised UCC ups the limit on the UCC statute of frauds to $5,000, whereas the current UCC has the figure 500. So that figure may be going up in some or all jurisdictions soon. Okay, so how does this apply then? Well, the basic rule of Section 2201 of the UCC is that a contract in excess of, or for the sale of goods in excess of $500 must be in writing signed by the defendant. It doesn't need to include all the essential terms, just like an offer under the UCC doesn't need to include all the essential terms, but you do need to have that one magic term, the quantity, remember. So the writing under the UCC statute of frauds needs to commemorate the agreement just like an oral agreement or offer would be valid under the UCC without all the essential terms included. There are some exceptions that we need to talk about under the UCC statute of frauds, though, and there's one exception here that I want to mention that has its own name or title, and it applies only to merchants. It's called the merchant's exception to the statute of frauds. And I think the best way to understand this is to go right to an example of how this works. Let's say we have two merchants. We have on one hand Apple as a merchant in electronic goods, and we have Walmart, who's also a merchant in consumer electronic goods. So just to sort of oversimplify the way this would work in real life, let's assume that a representative from Apple gets on the telephone and calls Walmart. And they're discussing a contract, and there's an offer made over the phone from Apple. They want to sell 500 iPads at $500 a piece to be delivered, by June 1st to the warehouse in Chicago, Illinois that Walmart owns. So Walmart says, yes, that'd be great, we accept, and they make this oral agreement over the phone. Then the merchants hang up the phone, and the representative from Apple does what I would advise all of you to do, and it's best practice, is that immediately after an oral conversation, you want to write a written memorandum of that conversation. So a representative from Apple sits down at his or her computer and types out an email to the person at Walmart that says, it's my understanding, based on our conversation from earlier today on the telephone, that we agreed to the following, and then list the terms: 500 iPads, $500 to be delivered, the date, the place, etc. And then the representative from Apple sends that email, what we call it an email confirming the oral agreement, to Walmart. Walmart representative receives the email, reads it, but doesn't respond to it, ignores it. Several days go by, several months go by, and then all of a sudden it's June 1st, the time for delivery, and the iPads show up at the Walmart warehouse. Walmart says, well, wait a minute. we didn't order these. And Apple says, yes, you did. And there's an argument that ensues, and Walmart eventually says, well, we have nothing in writing. These are goods in excess of $500. So even if we did agree, it's unenforceable, statute of frauds. Okay, what's the result there? Well, if we run through our elements of the merchant's exception, we'll find out if there needed to be, under those circumstances, a writing or not. So the first element is that both parties must be merchants, right? They're in the business of buying and selling goods of a particular type. Well, in my example, I told you they were both merchants in consumer electronic goods, so we meet that element. Second, within a reasonable time after making the oral agreement, one party sends a written confirmation of that agreement to the other. Okay, and in my example, I said that as soon as the representative from Apple hung up the phone, he or she typed an email, right, which is a written confirmation of the oral agreement, and then sent it to Walmart. So we would meet that element too. Immediately would be within a reasonable time, and we send a written confirmation of the oral agreement. The next is that the written confirmation sent, is definite enough to bind the sender. In other words, it includes enough of the essential terms that a court could tell what the agreement was. And it's definite enough to at least bind the sender of it. And then last, the receiving merchant, this is Walmart in my example, fails to object within 10 days of receiving the confirmation. So 10 days after the Walmart representative receives the email, fails to respond, doesn't respond at all or ever, then this exception applies. Notice what's wrong or what's missing. You might be wondering, well, wait a minute, there's an email, there's a writing, right? And what doesn't that satisfy the statute of frauds? And you'd be right, but notice what's missing that the statute of frauds requires. There must be a writing signed or acknowledged by the defendant or the party that is now claiming that there was no agreement that existed. And in that case, it's Walmart. Okay, so Walmart might come forward and say, well, no, that written email, that was unilateral. That was sent from Apple to us. We never signed anything. We never acknowledged any writing. There's no writing under the statute of frauds, and so therefore our contract is unenforceable. The merchant's exception to the statute of frauds would apply under those facts and would eliminate the need for a writing signed by the defendant. That's what the merchant's exception does, is it eliminates the signature requirement by the defendant or the person that's denying the existence of the contract. So one note of caution I would give you about the merchant's exception to the statute of frauds, and that is if you see a question on a quiz or an exam that has a fact pattern with a statute of frauds question in it, and one of the multiple choice answers is the merchant's exception to the statute of frauds, be careful, because this is a very narrow circumstance where this applies. You have to have two merchants. You have to have all these elements present where you have the oral contract and the written confirmation, and then the receiving merchant doesn't reply within 10 days. Then all it does is eliminates the need for a signature by the defendant or the one denying the existence of the contract. So you have to have a very narrow set of facts for this merchant's exception to be the right answer, right? And I know from experience that students, they see this answer on a multiple choice question and they say, oh, the merchant's exception to the statute of frauds. That sounds right. That sounds like it could be right. And so they pick it. But just make sure that you have all these very specific circumstances before you go ahead and choose that as the answer. Okay, some other special exceptions to the statute of frauds under the UCC. And again, I have to remind you that an exception to the statute of frauds means that an oral agreement is sufficient, right? Statute of frauds says we need a writing. So if we have an exception to that, we must mean that an oral agreement is okay and enforceable. So here are three more special exceptions under the UCC where an oral agreement would be okay. The first one of those is that the seller specially manufactures the goods for the buyer, okay, or the specially manufactured goods exception. So let me give you an example of this really quick, and I think you can understand. You'll see the reason for this. Let's say we have a local business like a bank, and the bank has a lot of employees, tellers, and account representatives and those folks. And the bank wants to go ahead and buy some polo shirts for all their employees to wear, on casual Friday while they're working at the bank. And so they go to the local shirt seller and they order all these shirts, like more than $500 worth of polo shirts, and the shirts are going to be engraved with the the names of the employees and the bank's logo, and the polo shirts are in the bank's colors, which happen to be some sort of horrendous purple and green or something. And so they order all these shirts, more than $500 worth of the shirts, but they don't have anything in writing. Representative from the bank just goes to the shirt seller and gives the order orally, and shirt seller says, okay, those will be ready in 8 weeks or whatever, and they agree on the price. So then 8 weeks later, shirt seller calls up the bank and says, yeah, your shirts are ready. And the bank representative says, oh yeah, about that. Yeah, we've got economic downturn, whatever. We can't afford the shirts now. Sorry. Oh, and by the way, those are goods in excess of $500, and there's no writing signed by us. There's no writing at all, and so statute of frauds. That contract is unenforceable. And the bank would be right. However, this probably fits into the specially manufactured goods category, where the buyer had these goods specially manufactured. Remember, the shirts were going to be stitched with the employee's name and the bank's logo and these in the bank's colors. They were specially made for the bank. In this case, we say this is an exception to the statute of frauds. We don't need a writing. And if you think about it, it makes some sense, because what's the purpose of the writing in the first place? The purpose of the writing, the reason we require a writing ever under the statute of frauds, is to provide us with the best evidence that an agreement really did exist. Well, if we have specially manufactured goods, we can look at the shirts in this case and say the shirts are the writing. The shirts are evidence that the parties had an agreement for these things, because why else would the shirt maker go ahead and make up more than $500 worth of these shirts in the bank's colors with the bank's logo and the bank's employees' names on them unless they had an agreement to do so? So you would say that is evidence. The shirts are the evidence that the parties had an agreement, and so we don't need a writing. And so that's kind of the justification for this exception to the statute of frauds, where we have specially manufactured goods, where the seller specially manufactures goods for the buyer. The goods are the writing, so to speak, and so we don't need a writing. And the next category here is if the defendant admits in court that there was a contract. Okay, so sometimes a party will say, no, there's nothing in writing. We never had this oral agreement. I'm denying the existence of the oral agreement. And there'll be a lawsuit filed. And in the course of the lawsuit, the defendant, the one who's denying the existence of the oral contract, under oath and on the record, either testimony in live court or in a deposition, prior to a trial, will say under oath and on the record, yeah, we had an oral agreement, but there's no writing. Well, if the defendant ever admits under oath and on the record that he or she made an agreement, then that counts as a writing. That's an admission, right? We don't need a writing to prove that there was the existence of a contract. We have the defendant's admission that there was one. So we don't need the writing. So if the defendant ever admits in court or under oath that there was an agreement, then we don't need a writing signed by that person. And then last here we have the category that says if the goods have been delivered or paid for in part. So this is what we call like the part performance exception. So let's say one more example here. Let's say that I have a shoe store and I contract with Nike, and I'm going to buy 50 pairs of shoes from them. But we don't have anything in writing, and the 50 pairs of shoes happen to be more than $500. So normally this would be one of the categories of the statute of frauds, but we don't have anything. If Nike delivers 30 of the 50 pairs, then denies the remaining 20 and says, yeah, well, we've delivered 30, but we can't, or for whatever reason don't want to deliver the other 20. Oh, and by the way, we don't have a writing signed, and so statute of frauds. The contract would be enforceable as to the 30 pairs delivered. So I would have to pay for those. But the remaining 20 pairs I would not have to pay for, and they would not have to deliver because we don't have a writing indicating that we had that agreement. But when we have part performance, like the delivery of the 30 pairs of shoes, that serves as an exception to the writing requirement because, if you want to think about it, the part performance is evidence that we had an agreement. Why would Nike deliver 30 pairs of shoes to me unless we had an agreement to do so? Okay, this last part of our material here deals with something called parole evidence, or the parole evidence rule. And it has to do with a writing or a written contract. but really it's a rule of evidence about what a court will consider and what it won't consider in trying to determine the parties' claims as they relate at least to a writing. So a couple of terms I want to get out of the way here before I start talking about the rule, the parole evidence rule. First is, what is parole evidence? Parole evidence is any evidence other than the written contract itself, which was said, done, or written before the parties signed the written agreement or even as they signed it. Okay? So parole evidence is anything, and sometimes you'll see courts refer to parole evidence as anything outside of the four corners of the document itself. Right? So these are comments made by the parties as they're signing, or maybe right before they're signing the document. That's considered parole evidence. I always like to tell students, think of the word parole as meaning outside. It's like outside evidence, outside of the document itself. Okay, so then another term that we have to be familiar with is an integrated contract. Integrated contract is a writing that the parties intend to be the final and complete expression of their agreement. So a lot of times in negotiating for a contract, there's a lot of bargaining back and forth, oral discussions, but only certain of their discussions and terms make it into the writing. When the parties write down what their oral agreement was, then we assume that they wrote down what their final agreement was intended to be. So an integrated contract is one that the parties intend to be their final agreement, and therefore excluding any of those conversations and other possible bargains and things that were talked about prior to the writing. Okay, so let's get to the rule itself. Parole evidence rule basically says when two parties make an integrated contract, one that they consider to be final, then neither party may use parole or outside evidence to contradict, vary, or add to its terms. Okay, so very clearly, if one party wants to contradict a term that was written into an integrated contract, the court will not allow them to use parole or outside evidence to do so. So a party can't come into court and say, well, I know the contract says this, but as I was signing it, we had a discussion and the defendant said it didn't matter to him. Well, the court's not going to consider that evidence. That's parole or outside evidence. So the court's only going to look at what's inside the four corners of the document, going to read the document, and not consider any evidence that's outside of it if that evidence is offered to contradict, vary, or add to the terms of the writing. Okay, to eliminate questions that come up sometimes about whether a contract is intended to be the final contract, a lot of contracts will include this language called an integration clause, right? And basically it's in there to eliminate any potential claims that the writing is not final. An integration clause in a contract is language that states that the writing contains the parties' full agreement and they're not relying on any statements made prior to the signing. So basically it's a statement in the contract that says we, the parties to this contract, intend for this to be the final agreement. Okay. So let's look at some exceptions to the parole evidence rule. Parole evidence rule, remember, means that a court will not consider outside evidence. So an exception to that must mean these are times when a court will consider outside evidence. Okay, so the first exception is if the writing itself is incomplete or ambiguous. Then the courts might consider parole evidence to help the parties complete the written contract. All right, so let's give an example of this. Let's say that we have a local sheriff who is going to hire a sheriff deputy. And there's going to be a contract of employment. They're going to have a written employment contract, and they discuss the terms. And we have Deputy or Sheriff Taylor, and he's going to hire Deputy Fife. And during their discussions, Deputy Fife is very insistent that he be allowed to carry a gun when he's on patrol. And Sheriff Taylor's not too convinced of this, that this is a good idea, but in their oral discussions, they talk about carrying a gun, and finally, Sheriff Taylor says, okay, I guess that would be okay. I'll allow you to carry a gun while you're on parole, or while you're on patrol. And so they go to write down their agreement in their written employment contract, and in the contract it says that Deputy Fife will be allowed to carry a weapon, but it doesn't specify. what kind of weapon, or it doesn't get into the specifics. It just uses the word weapon. And both parties sign the agreement. After the agreement's signed, then Deputy Fife shows up with a gun, and Sheriff Taylor says, no, that's not what I meant. You can't carry a gun. Here's a nightstick. This is your weapon. Right? If there's a dispute about this, about what the word weapon meant in the contract, and we end up in court for some reason about this, a court would consider parole evidence because it would be offered to complete the contract or to clear up an ambiguous term. So Deputy Fife would be able to bring in evidence of the conversations with Sheriff Taylor where he agreed that it would be a gun that would be the weapon. And that would be evidence that he could bring that would be outside of the four corners of the document, but a court would consider because it would shed some light or clear up some ambiguous terms. Another exception to the parole evidence rule here is anytime there's obviously a claim of fraud or duress, we would need to refer to parole evidence in order to prove it, right? Otherwise, people would lie to you all the time, commit fraud, and then write down something completely different than what you orally agreed to and say, nope, you're stuck with the four corners of the document. What it says is what the court's going to enforce. And, strictly under the parole evidence rule, the court wouldn't be able to consider the statements made inducing the person to sign the contract. In other words, the false statements, the lies, the fraud. Well, clearly, courts are going to consider those statements when there's a claim of fraud or duress or the